Hello and welcome to this Modern Criminal Law Review Plus special issue workshop on criminal law and language. My name is Morten Boe. I'm a doctoral researcher at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg, Germany, and it's my very pleasure to serve as the moderator of this workshop, which really brings together an international and interdisciplinary group of scholars to reflect on the intersection between language and the law and governance of crime and punishment, quite broadly construed. Today's participants, whom I will introduce later in a bit more detail, include in alphabetical order Anya Bernstein, John Conley, Oliver Gerson, Tatiana Grieshofer, Jean-Louis Halpérin, Janny Leung, Arpeeta Mizan, and Riner. And since we are a rather large group today, we will split the event into two panels. After each round of presentations, there will be a panel discussion regarding the papers or presentations of that panel, but every participant will be allowed to engage in the discussion. And in the end, there will be time left for an open discussion to address more general questions. And for that, there will also be the opportunity for you and the audience to engage in a short Q&A section. To participate, you can just post your questions or comments in the YouTube chat, which I will then read out to the participants. And without further ado, let's begin with our first panel. Our first presenter today is Professor Anya Bernstein, who is Jesse Root Professor of Law at the University of Connecticut. Please go ahead.
Thanks very much. It's really a pleasure to be here. It's an exciting opportunity, and I'm excited to be in conversation with everybody else here. The paper I'm planning on writing builds on a paper I published a couple of years ago about legal corpus linguistics. And I want to expand the discussion I had in that paper to encompass concepts of ordinary meaning, because the work I did in that paper has implications for ordinary meaning, or the philosophy of interpreting statutes through ordinary meaning, that I didn't fully pursue in that paper, and so I'm using this as an opportunity to think about that. This work isn't really specific to criminal law in particular, but it's particularly fraught in the criminal law area because, of course, the way that courts interpret criminal laws has deep implications for personal liberty and the threat of sanctions to people implicated in the criminal justice system. So let me start off with just talking a little bit about corpus linguistics and how it gets translated into the law. And I think that'll kind of pretty clearly broaden me out to the question of ordinary meaning. Corpus linguistics is a method of linguistics in the domain of functional linguistics, so people who are interested in looking at how speakers actually use language. And what it does is it takes data sets, often large data sets, to investigate the patterning of how people speak or write or whatever, communicate. In that sense, it's fundamentally empirical. It looks at how language users participate in situations of language use, and it shows how they participate in, obey, change, help constitute genres of language within particular frames of social action. So how do academic writers use set phrases in academic work? How do writers of social media posts use slang in their social media posts? Stuff like that. In the last decade or so, this approach has been taken up in a modified form by legal scholars and judges in legal corpus linguistics. Legal corpus linguistics also uses large data sets to investigate how people talk, but it does so for a slightly different purpose. Rather than seeking to analyze how the speakers within the corpus use language, it seeks to use these corpora to understand how the speakers within the corpus would understand legal language. So in other words, it's looking at the language of the audience for legal speech and trying to use that to understand how that audience will understand legal speech. So where corpus linguistics asks, how do speakers use language? Legal corpus linguistics asks, how do audiences understand language? And looks to corpora of audience language use to get a sense of that. The problem is that it lacks an articulated theory of how these things are linked. Why should the way that an audience uses language represent the way it would understand a totally different genre written by totally different people? And just to give you an example of what I'm talking about here, you could take a corpus of every instance in my life in which I have used the word fire, but it would not help you understand how I understand my kid, my 14-year-old, when he sits with a friend eating donuts and says, "This donut is fire." I know what he means because I've been around teenagers enough to know that fire has meanings other than the meanings that I use it for. But you'd never know that from looking at a corpus of my speech, because I don't use fire in that way. So same thing goes for the kinds of ordinary speakers captured in the corpora that legal corpus linguistics use. So as you can probably already tell, the critique I offer of legal corpus linguistics specifically kind of applies to ordinary meaning as well. So the rule of ordinary meaning in statutory interpretation is simply that legal language should be interpreted to mean what an ordinary speaker or reader would understand it to mean. That's basically the argument of legal corpus linguistics too, as I just described. So it has the same problems. Like legal corpus linguistics, the ordinary meaning approach isn't an empirical analysis or even an empirical claim. It's a normatively based prescription about how we should treat legal language. It also matters that legal language is a very particular genre of language use. Like all language use, it happens within particular sociocultural settings. And it makes sense with reference to the parameters and patterns of those settings. So genre constraints, how people understand each other within frames and contexts. Using the ordinary meaning of an individual word in a statute doesn't really get at the way those words go together to create constraints and restrictions and regulations within the statute. And statutes in particular are incredibly dense, complex, interconnected forms of language. And there just isn't any ordinary genre that resembles the way statutes work. I mean, thank goodness. Imagine all of us speaking and, imagine getting an email that looks like a statute. You'd never understand what it means. It's not an ordinary genre. So looking for ordinary meaning in a statute is not a simple linguistic exercise to the extent there ever is such a thing. Rather, the insistence that we interpret statutory language through ordinary meaning is a normative choice. It's a policy commitment. And in the language of US statutory interpretation, it's a substantive canon. A substantive canon is basically a policy commitment that courts deploy in order to push legal interpretation in some particular direction that might not be obvious from the language. That's contrasted with a linguistic canon, which is supposed to reflect how people actually speak, with an emphasis on the supposed to. So recognizing that ordinary meaning is actually a substantive canon, I think frees us up a little bit to recognize more about the work that courts actually do and to think more creatively about how we can fulfill the policy commitments that ordinary meaning is supposed to serve. It lets us see quite clearly that courts can't take a chemical assay of meaning and say this is what the statute means inherently. Rather, like all interpreters and participants in sociocultural communicative exercises, courts participate in producing meaning and they help effectuate statutes. That allows us to weigh this particular policy commitment, this substantive canon, against others. So we can think about what's the value, what is the policy commitment of ordinary meaning? Usually it's described as fair notice. So the idea that the people who are governed by a law should be aware of what the law requires. That seems like a very important value for democracy. But it has to be weighed against other policy values, and it has to be considered in terms of how it can actually be effectuated. So some of the other important policy values we might lay it against are something like lenity or decarceration, or even the separation of powers, because part of what insisting on interpreting statutory terms through ordinary meanings does is it basically instructs Congress how to legislate. It tells Congress how it ought to form its words. There's no clear constitutional mandate for that, or any legal mandate for a court telling Congress how to legislate. More broadly, however, I think it's important to consider whether it's statutes specifically that need to bear the work of fair notice. A statute, for instance, often distributes the labor of ensuring notice. A statute will say, here's something that needs to happen, and here's an agency that needs to figure out how it happens and make a rule that explains to people how it should happen. Administrative agencies do that all the time, and their rules, although also quite specialized, are at least a lot easier to understand and a lot more familiar than statutory language usually is. That suggests that fair notice of what the law requires is not just something that the statute has to do, it's a whole of government responsibility. And I think in criminal law, in the criminal law arena, that becomes particularly important because it reframes criminal law implementers, like agencies, but also like police and prosecutors, as kinds of administrative agencies that have deep responsibilities to the people they govern in terms of clarifying what the law requires and how they understand the law. Taking some of that pressure off of statutes and redistributing it to other actors who are actually in a better position to make clear what the law requires in a way that fulfills the policy commitments of ordinary language without imposing a totally unrealistic and empirically unfounded understanding of statutory language. So that's my contribution. Thanks, everyone. I look forward to hearing your comments.
Thank you. Very interesting. Up next is Dr. Oliver Harry Gerson, postdoc at the Faculty of Law at the University of Passau. Freiherr, please.
Thank you very much for inviting me to speak on such a fascinating topic. Today, I would like to talk about the growing difficulties that arise when criminal law concepts become shaped by moral, emotional, and political language. The title of my contribution in my paper is Criminal Law Under Semantic Pressure. I've done a lot of research to it. I will show you a sociological and philosophical approximation to it, and yeah, let's see. The main question is, what remains of criminal law language once its words begin to absorb narratives from outside law? At that point, words risk turning into semantic vessels that can be filled with shifting moral, political, and emotional content. For Wittgenstein, such a condition would resemble a linguistic nightmare, a state in which conceptual boundaries dissolve. Worüber man nicht sprechen kann, davon soll man schweigen. Whereof one cannot speak, thereof one must be silent. In criminal law matters, we increasingly speak with concepts whose boundaries have become unclear, overloaded, and unstable. But step by step, to clarify the foundation. Criminal law begins where moral certainty becomes insufficient. The authority of criminal law depends on conceptual precision. Today, however, criminal law operates within a public discourse shaped by morality and emotion. Political rhetoric, social media communication, and activist language transform legal concepts into symbolic markers of collective moral condemnation. The deeper problem here lies in the growing influence of external narratives on legal interpretation itself. Criminal law, therefore, and that's my word for it, operates under conditions of semantic pressure. What is semantic pressure? Many criminal law concepts are currently undergoing processes of semantic expansion. Terms we all know, such as violence, hate, discrimination, harassment, terrorism, genocide, are used beyond their doctrinal meaning. Therefore, or thus, they often function as instruments of moral positioning. Three developments appear particularly relevant. First, moralization. Legal concepts serve as vehicles for collective condemnation. If someone uses, for example, violence to achieve political or social goals, society must respond firmly. There can be no tolerance for violence. Okay, at first glance, this seems obvious, but as always, the devil is in the detail. We will come to this in a moment. Second, emotionalization. Criminal law language becomes linked to emotional experience and symbolic harm rather than to clear legal conduct. For example, people speak of hate or of discrimination in situations that may be morally troubling without any doubt, but that do not satisfy the legal requirements associated with those concepts. And third, politicization. Criminal law terminology becomes embedded within broader ideological conflicts and identity-based narratives. For example, terms such as fascist or terrorist are often used to classify and to ostracize political opponents before any legal assessment has taken place. As a result, the distinction between a clear legal judgment and political evaluation becomes unstable. Two, what are the methodological problems that result? This described development creates several tensions. First, criminal law, as I said before, depends on conceptual stability and semantic restraint. Legal categories must remain precise in order to ensure legality, foreseeability, and equality before the law. And there it conflicts, because criminal law depends on semantic restraint. Political, emotional, or moral communication reward semantic escalation. Second, criminal adjudication operates through evidentiary discipline. Political and moral discourse, however, often operate through emotional plausibility in the sense of, I know it when I see it. And third, and most important, criminal law risks losing its methodological autonomy. The problem lies in the semantic overloading of legal concepts. There are two ways this can happen. Doctrinally precise categories are replaced by vague expressions taken from political or activist discourse. In other cases, the legal concepts themselves remain formally unchanged, but they become filled with additional moral, emotional, or ideological meanings. Legal concepts thereby begin to absorb expectations and narratives that originally emerged outside the legal system. Niklas Luhmann would probably say that different forms of communication are becoming mixed together, even though they are not structurally compatible. The problem? The more meanings are inserted into a remaining concept, the more difficult it becomes to preserve its limiting functions. I will illustrate it with an example I already mentioned, violence. Traditionally, criminal law linked violence primarily to physical force, a punch in the face. Contemporary political and academic discourse, however, includes symbolic violence, structural violence, epistemic violence, linguistic violence, financial violence, emotional violence, I don't know, whatever, and so on. At some point, one must ask what these concepts are still actually meant to describe. These concepts from out the law may reflect important social and philosophical observations, maybe. Yet from the perspective of criminal law methodology, they only create difficulties. The more meanings we put into the concept of violence, the harder it becomes to distinguish crime from social or political conflict. The more meanings that are absorbed into the concept, the more it loses its limiting function. This produces what may be called semantic inflation. If violence comes to include everything, coercion, threat, emotional discomfort, offensive language, social pressure, or symbolic exclusion, the concept gradually becomes analytically empty. Put simply, if everything is violence, then nothing is. What follows? The deep danger is epistemic destabilization. Under these circumstances, and they are increasing, they're getting more and more, the pressure raises, criminal law shifts from evidence-based attribution toward effective interpretation. Some normative reflection. To again borrow Wittgenstein's famous image, criminal law risks becoming trapped inside a semantic fly bottle of its own making. Concepts circulate endlessly between politics, media, moral emotions until their contours begin to dissolve. The challenge is therefore to find a way out of this semantic fly bottle. So what to do? To make it clear, criminal law cannot entirely isolate itself from moral, emotional, and political language. Punishment necessarily contains elements of moral condemnation and social communication. Nevertheless, criminal law must preserve a distinction between legal judgment and political moral labeling. Its authority depends on its capacity to resist semantic inflation and conceptual overexpansion. Therefore, criminal law concepts must remain narrow, technical, and conceptually clear. Double meanings and semantic ambiguity should be avoided wherever possible. In a nutshell, criminal law is the natural enemy of vague concepts. The purpose of criminal law is not to provide a general description of social phenomena in the whole world and the moral experiences of all the inhabitants. Its task is very, very narrow: to place legally relevant facts into clear legal categories. So what's my conclusion to this point? The central challenge for criminal law language, therefore, is not simply the growing influence of morality, emotion, and politics on the language, but the gradual collapse of conceptual boundaries between legal reasoning and moral political narration. But there still is a reason for optimism. Criminal law can survive the moral conflict. Criminal law itself possesses its own internal safeguards: doctrinal structure, evidentiary discipline, and the principle of legality. Therefore, criminal law gains its authority by transforming social conflict into disciplined legal judgment. Few words, clear meanings, narrow concepts. Better too narrow than too broad. Only a criminal law that disciplines its own words, its own concepts, has the power to discipline others. To sum it up, the limits of criminal law language define the limits of criminal law judgment. Thank you very much.
Thank you indeed. And our next presenter is Professor Tatiana Grieshofer, professor in language and law at Birmingham City University. The floor is yours.
Thank you very much. It's very nice to be here with everyone. I will share my presentation now. I hope you can see it.
Not yet.
Yes, hopefully now.
Yes, now we see it.
And I will just share it as full screen. I hope it's working.
It's working. Perfect.
Okay, thank you so much. I'm Tatiana Grieshofer, and my main research develops the theory and practice around legal consciousness, with the main focus on legal interactions across the different stages of the legal process. So I've conducted studies rooted in digital ethnography, courtroom ethnography, combining quantitative and qualitative approaches, specifically focusing on high volume proceedings where at least one of the parties is not represented. So typically it is family courts, small claims cases, employment tribunals, and especially in family courts, cursive elements of cursive conduct is kind of present in all the hearings that I've ever observed, to be honest. And this project is a collaboration with my colleague Laura Hammond. She's professor of psychology, and her research is very much related to crime and society and the different kind of spatial patterns, geographical profiling, and modeling of crime. And crucially, also the lived experiences of victims, specifically domestic abuse victim survivors across the different stages of investigative processes and decision-making processes. So this is the reason we wanted to sort of start a new project on domestic abuse cases, and especially the crucial part of evidential stage, which is linked to risk assessments. But we are viewing risk assessments as part of the, as a crucial part of the whole legal process with respect to, from the victim's perspective, procedural justice, and from the procedural perspective, procedural fairness process. So we are focusing on domestic abuse as one type of the violence, as kind of Oliver already mentioned, and obviously one of the reasons we wanted to specifically focus on domestic abuse is because it's a growing issue on the global scale. Intimate partner violence has been defined for a while now as a global public health issue, with 1 in 3 women worldwide sort of being shown having some lived-in experience of physical and or sexual intimate partner violence or non-partner sexual violence experience. And there are lots and lots of different types of risk assessments. The list is very long, and it's only the list that is relevant to English-speaking countries. But there are a lot of challenges with risk assessments. And so part of the presentation is to talk about the different types of domestic abuse and the different challenges with risk assessments. What I have observed from my court observations across family courts, criminal courts, is that even the same type of case, the same type of partners would be assessed in different ways with respect to their cases in family courts as opposed to their cases in criminal courts. And the same risk assessments applied to the same situation and the same partners would not necessarily be equally applicable across the different types of contexts. And this is something that is really important. It's a linguistic challenge in many different ways. So what we know from family courts is domestic abuse is an everyday business. And obviously the focus of family courts is on the welfare of children. The risk assessments are not as well established in family courts, and there are a lot of questions as to how they're used, and also which ones need to be used there, because most of the risk assessments are still focusing on the inter-partner relationships, but not necessarily incorporating the voice of children. And in criminal courts, then the risk assessments are much more established, but they experience another type of challenges related to crime data tracking. To what extent crime reports are shared, to what extent domestic abuse case can be tracked from the first report through to court, and that impacts the effectiveness of risk assessments. So just to give you a general idea about the domestic abuse data, this is obviously for England and Wales, but I think it's a similar picture elsewhere. These are just the graphs showing the difference between the incidents or the progression from incidents to conviction. The estimated number of victims is much, much greater than the number of incidents that recorded by the police, and we can also see kind of the gender balance, females and males here, but that is only with respect to estimated victims. What happens when cases get to the police? Some of the incidents are simply filed because there isn't enough evidence, and a larger, but still around half of those incidents are then recorded as crimes. So we will focus on risk assessments and how they're used by the police, and what their kind of trajectory is, and what that means for victims, police officers, and also the legal system and the legal process. There are a lot of challenges with risk assessments. I already kind of referred to some of them, but it's a very interdisciplinary type of genre. There are a lot of disciplines that should be in place. Very often it is mainly criminology, potentially criminology and forensic psychology that is incorporated into the risk assessments, but the list of the disciplines that are very relevant to risk assessments is much larger. So with respect to criminology, obviously, it is the crime patterns and police work realities that need to be reflected in the risk assessments. But equally, from the perspective of forensic psychology, the trauma-aware approach is incredibly important, because one of the issues with risk assessments is that if victims feel re-traumatized at that very early stage of eliciting their narratives, then they're not very likely to proceed to the further stages, or maybe even decide to drop out from that risk assessment at the beginning. From the legal perspective, what risk assessments open up is the different legal pathways that individual cases can follow, and the quality of the evidence that is collected as part of the risk assessments defines the reliability of the victim statements and the quality of their testimony. Obviously, the risk assessments are there to elicit the narratives and the evidence, and they're not necessarily fully tested as part of the follow-on legal process, but there are other ways in which they can be tested. With respect to social legal studies, risk assessments are very important for the victims' feelings of and perceptions of procedural justice and the procedural fairness process, and they define to what extent victims can effectively participate in that legal process. But obviously, there are also other factors in play with respect to socio-political and socio-cultural realities within which courts operate. And finally, language and communication is incredibly important, but always incorporated into risk assessments. It's building rapport relies on communicative and discursive practices that are applied by individual police officers in individual circumstances. And it is the quality of the narrativization and elicitation strategies that defines the quality of the evidence that is collected. What is also interesting about risk assessments from the linguistic perspective is that very often in the legal process, we talk about legal aid discourse and legal aid interactions. But actually, when it comes to risk assessments, what happens is, because they're conducted by social services, police officers, sometimes healthcare workers, the context is slightly different. It's lay, semi-legal, or to be more accurate, lay professional type of interactions that happen, and those are for the for the legal. They happen in legal settings, and they're related to the follow-on legal proceedings. And equally, the risk assessments, when they are sort of collated as part of different models, so some models are automated, some are evidence-based models, which are more linked to the sort of professional practice. But what often is not necessarily incorporated at the very beginning is the localization. And so I'll mention that. I'll come back to that later on. So this study that I'm presenting now is based, is a first study that we, or the first stage of the study that we are working on. It's based on textual ethnography and semi-structured interviews. The textual ethnography element is linked to the risk assessment templates. And what I think is quite crucial about that is that a template can be looked at, from different perspectives. And one of them is, it's a starting point for evidence collection from the police officer's perspective, but it is equally a summary of the interaction and narrativization from the perspective of the legal process. And from the victim's perspective, it is their opportunity for the voice projection, for this narrativization. The other part, the other method employed here was semi-structured interviews. And it's fascinating, and I've used this in some of my previous projects. What I find really fascinating is that the moment the interviews focus on language and interaction, it creates this really nice opportunity to not only collect the data for the empirical research, but also it's a reflective type of practice. And so the interviews we conducted with police staff involved in domestic abuse desk assessments served also as a reflective practice for them to explore their professional institutional practices and at the same time reflect on the victims' lived-in experience and what defines their perceptions, victims' perceptions, and also police officers' perceptions of victims' sort of access to procedural justice. It's a very it's a way of prospectively looking at the imaginary on best practices, challenges, and opportunities for change. And this study will be built on in a couple of months' time when we'll start looking at discursive practices of the evidence that is collected in the actual video recordings and audio recordings of the risk assessments. So just to kind of start with the pipeline of what happens and at which stage the risk assessments are collected. So usually it starts with an emergency call where the initial information is elicited. And if the dispatch desk sort of identify an element of domestic abuse, then another team makes a decision on whether the victim or the victim survivor requires an in-person sort of support or if they prefer a video response. And the video response is something that was only recently introduced, and for victims to be offered the video response, they need to there are a few requirements that they need to fulfill. First of all, it is based on the caller's preference, different safety considerations, obviously, legal needs, communication needs. So if they need an interpreter, then usually it would be an in-person sort of risk assessment that is conducted. But the video response rates are very good and high satisfaction of victims with video responses. So this is what I will be focusing on at the moment. And there are several communicative aims for the domestic abuse desk assessments, so risk assessments. Once the case gets to that stage, the police officer either records or negates the offence, they conduct foundational investigations, and importantly, they also complete the risk assessments. But as part of the risk assessments, they also offer safeguarding advice. If there are any children involved, then they follow voice of the child principles. They kind of conduct referrals and also, where appropriate, effective suspect management. There are also kind of interesting follow-on stages that happen after the risk assessments. The risk assessments are reviewed, and there is a very sort of in-depth review process that is incorporated into that, depending obviously on what happens with the risk assessment and the outcome. And with respect to case progression decisions, the case either is prosecuted by the Crown Prosecution Service with the victim's consent, or even without the victim's consent, which is then called evidence-led prosecution. And then there are different options for out-of-court disposals or closing the case, filing the case. What is essentially with respect to the voice of the victim, the important part is that risk assessment, because it provides that opportunity for them to share not only what happened to them most recently, but also the pattern of the abuse that they have been experiencing. We also know from legal literature that one of the challenges that lay people have, and that applies across different civil and criminal contexts, is that they struggle with identifying their legal needs. And risk assessments, the way they're conducted, and I'll show you the templates on the next slide, is they help identify safeguarding and legal needs. So they play that really crucial part in the legal process. They also determine access to police resources and legal outcomes. And equally, it's, as I said before, it's the main opportunity for victims to share their voice, to share their narratives, and get access to procedural justice, or their perceptions of procedural justice. So this is one example of the domestic abuse risk assessment, which was introduced in 2022. It's an improvement in the previous version. This is just the first image to show how it looks as a template. The questions are, there are only 18 questions, and most of the questions start with how often. Now that in itself is quite important, because how often obviously focuses on the repetitive pattern. And we then have questions according I categorize them here on the slides. The first question starts with the threats to harm. Then we're moving on to emotional abuse and calling names, humiliation, degrading someone. And then we're moving to controlling behavior, different types of controlling behavior, from controlling activities to financial abuse, denying access to money, following, stalking, harassment, monitoring location, phone, email. So 4 questions related to control. Then we have one question related to the feeling of isolation, and then several questions related to physical violence, strangulation, attempts to choke, suffocate, or drown, and use or threats to use weapons, household items, knives, or guns. So, yes.
I'm very sorry, but I think we have to move on.
Yes, that's
slowly.
fine.
So if you want to wrap up, thank you.
So that's actually good timing. I have kind of one final point to make, is that we have the how often questions and the number of yes/no questions, which are related to the different risks. So whether they recently separated, whether the victim is pregnant, and so on. But what actually is important is that there is, and this is something that comes out from the textual ethnography part and also the interviews, that there is scope for improvement with respect to collating more quality or better quality evidence. So recording first instances, because the question how often doesn't quite cover that. Then expanding exemplification of broader categories, so sort of making those semantic categories clearer. Acknowledging the ever-increasing and ever-changing role of social media, and impacting the or incorporating religious and cultural beliefs, and a bit more clearer focus on sexual violence and victim vulnerabilities, not simply what happens to them, but also sort of contextualizing that within their specific victim vulnerabilities, and essentially also expanding the scope beyond the intimate partner dynamics and making those kind of communicative boundaries clearer with respect to the perceptions that come from victims as opposed to perceptions that come from the police officers. Thank you very much. I will stop sharing my screen.
Yes, thank you very much. And the last presenter for the first panel is Professor Jean-Louis Halpérin, who has recently retired from his position as Professor of Law at the Ecole Normale Supérieure in Paris, France. And looking forward to your presentation. We see the presentation in perfect shape. Thank you.
Thank you. My issue is an historical inquiry about the use of vocabulary in the 3 French penal codes. The first one, the revolutionary one, in 1791. The second one, the Napoleonic Code, in 1810. The third one, the so-called Badinter Code, in 1994, which remains in force until today, with many amendments. My point of departure on the first slide is one surprising statement from Portalis, one of the well-known drafters of the Napoleonic Civil Code. He said in a discussion about criminal law that law is not a vocabulary, and you can see that for him, the choice of words in criminal law did not matter. I am opposed to this conception that is framed, according to me, by the idea of continuity of law based on natural law. I prefer, of course, the positivist conception, the one of Bernstein, and the idea that law and the vocabulary of law is constructed according to contextual needs and change alongside the time. And it's the reason why I try to study the difference of vocabulary inside the code. My method consists in comparing texts in the free codes and their amendments with the vocabulary used in this time by lawyers and by lay peoples, and to evaluate the changes in vocabulary. For example, for the first French code, the 1791 Penal Code, is the first one. I cannot compare with a previous code, but I can make comparison with the contemporary dictionaries. The Dictionnaire de l'Académie Française, first edition in 1762, and the very well-known encyclopedia from d'Alembert and Diderot with the use of many words of legal vocabulary, and a few treatises or books of criminal law that existed before the French Revolution. And then for the Napoleonic Code, I make the comparison, of course, with the Revolutionary Code to evaluate continuity and change, but also the introduction of new words during times. And I use the same method from the more recent Badinter Code at the end of the 20th century, and the many changes that have happened during this time. If you see the first French Penal Code, what it is more striking is the suppression, the absence of a great number of words that were used in criminal law during the Ancien Régime, because many offenses of the Ancien Régime were suppressed by the first Revolutionary Code. It's a case, you can see, of blasphemy, heresy, crime of lèse majesty, suicide, sodomy, adultery, abuses committed by priests, public prostitution, dishonest plays or jugglers or comedian, concubinage, seduction, dwelling, simony, usury, and more technique words coming from Roman law, pecula, plagia, abija, stelonia. All these words were used in the criminal vocabulary before 1789. None of these words appear in the penal code because all these offenses were suppressed and were considered as valuable conducts without punishment. On the contrary, there are new words according to the new political regime, like civil servant, fonctionnaire en France, in French, constitution, gathering of people, clubs, which is a word coming from the English language. There are, of course, new penalties. Imprisonment was not a penalty before the French Revolution. It became the main penalty, and with new words. The French word gêne was a word used for torture, and that was used in a new meaning for solitary imprisonment. The French word fer, irons, was used for hard labor with irons. Hard labor, travail forcé, was a new word completely ignored before the French Revolution, like detention for some kind of prison. Murder, meurtre in French, It's the case of a new meaning. The word was known, but before, the specialists of criminal law considered that all homicides, including assassination with premeditation, were murders. And the code said, no, murder is homicide without premeditation and has to be distinguished from assassination, because in this code, murder was not punished by the death penalty. And I try also to use to study the words used for criminals. The French word delinquent, a special word for récidiviste, repris de justice, for suspected people, and the words used in some cases from some part of the society, for example, for workmen, ouvriers, that were designed in this text. If I am going to the next code, the Napoleonic one, that remained in force during a long period from 1810 to 1992 with many changes. Here, there is a great continuity in the vocabulary. It's 20 years after the first code. There is not a great change in vocabulary, but there are some changes. About penalties, the use of brand that was re-established, flétrissure in France, the survey of the police, the suppression of this kind of imprisonment that were fer, irons, or gêne, the punishment of adultery that was not punished, and the word was not used in the Revolutionary Code. The fact that there was the use of the word demency, craziness, that was not used in the previous code. About brigands, not the direct use of brigands, but the French word malfaiteur, wrongdoers, who remains until today with different meanings as a way to determine a special kind and a dangerous one of criminals. And then you have the new words that were added with the change of the Napoleonic Code during the 19th and the 20th century about penalties, for example, travail d'intérêt général, which is a community penalty, the suppression of hard labor, the suppression of words concerning the rural society, theft of crops, theft by domestics. New words, of course, like terrorism, and for rape, not a new word, it's always the French viol, but with a definition that appeared in 1980 that for the first time spoke of sexual penetration. That was not the case before. One surprising example is about homosexuality that was punished in France until during less than 40 years, between 1932, during the Vichy regime, and until 1980, what was punished was the homosexual relationship between an adult or a minor. Until 1942, homosexuality is free in France and not punished, and the word, and any word alluding to this kind of sexual relationship is absent in the codes. When it was introduced during the Vichy regime in 1942, the words homosexuality, that was known in French language since the beginning of the 20th century, was not used, but the wording was acts against nature. And of course, you know, it's the wording of the British legislation, of the Indian Penal Code, a very old-fashioned way to design homosexual relationship, but that remained in the French Code until the suppression of this offense in 1980. And for the last code, here you have a long list of new words concerning new offenses not all from 1994. Many of them were known before, but not in the criminal code and not with a special word: genocide, sexual exhibition, psychic disorder, discrimination, harassment, vulnerable person, misappropriation of data, narcotics that were for a long time in the a special code about public health and introduced later in the penal code, money laundering, blanchiment in French language, and here again, surprisingly, incest, incestuous sexual relationship were until 1910 punished as an aggravating circumstances in rape or sexual aggression. And it was only in 1910, very recently, that the word incest, of course, very common in the language, was introduced in the code as, I think, the symbol of a kind of taboo. We have new meanings about rape, suicide. For example, suicide is not criminalized, but incitation, advertising for suicide is from some years criminalized. And you can see also some words about new community penalties, the use of different ways. And also what was known before the Badinter Code, but not nominated in the code, the presence of victims, the function of penalties, prevention, amendment, reintegration, the mention of foreigners, and the idea that also some vocational penalties about citizenship, narcotics, car security were introduced. What are the question and perhaps, and I hope for your help, the limits of this method? In many cases, as I have explained, the suppression of a word corresponds, of course, to the suppression of the offense, to the decriminalization. And on the contrary, the introduction of a new word corresponds to a new offense and to the criminalization of a conduct that was not criminalized before. And one can say that it's very easy and that the choice of words is not so important. It reveals only, and it's not a plus-value, the process of decriminalization and criminalization. I think it's a case for many suppression or many new words. But also in some cases, the same words...
Yes. I'm sorry, we also have to move on. So if you could wrap up, please, that would be nice. Thank you.
Yes, the same word is used in other terms. There's the apparition of new words linked with techniques. And there is also the style that is used for the sentence, the phrase. the fact that the French criminal codes, based on equality, refer rarely to different parts of the society and prefer to consider anyone that commits a crime. My conclusion will be with a short example, the use or the non-use of the word slavery. At the time of the Revolutionary Code and of the Napoleonic Code, slavery existed in French colonies, and the word was not used in criminal code. And even if some drafters of this code compare hard labor with slavery or penal servitude, the code do not use this word. And more recently, in the Badinter Code and its change, the word slavery was introduced, has been introduced in the code to punish the conduct to enslave a person. That happens even in France, in rare cases, but it could happen. And I think that it's something that has a meaning about the use of vocabulary. Thank you.
Thank you very much. If you could stop sharing your screen, then
Yes.
we can move on, because this concludes the first round of presentations. So thank you all for presenting all these interesting perspectives of today's topics. And we now have roughly 10 to 15 minutes time. Let's see how it goes to have a discussion on these presentations. So please go ahead. Any questions, comments, you're free. The floor is yours.
Hi, my name is Janny. Can I ask a question?
Perfect. Yeah, just go ahead.
Yeah. So I thought Oliver's paper and Jean-Louis' paper kind of speak to each other in some ways. So I have a question for the both of you, if that's okay. For Jean-Louis, there are really interesting old vocabulary that you shared with us. Things like, dishonest displays of something, seduction, and acts against nature. To what extent do you think these older legal terms, when they were used at the time, display the phenomenon that Oliver was suggesting, some sort of moralization that becomes encoded in the law? And then question for Oliver, I think from your conception of the law, I feel like you've taken a stance that, the purpose of criminal law is to change behavior. I wonder whether you have any openness to the idea that maybe the law also serves some kind of norm setting functions. So that's a question for the both of you.
Okay, I can answer that. Generally speaking, moral terms are not present in French criminal codes in any period. And I think that when moral terms appear, like dishonest conduct or acts against nature, it's always about sexual conduct. And that for a long time, that is not the case today, but for a long time, jurists and the drafters of the code did not want to use any sexual word in the code, to use the word sex. And it was known, of course, that it was a question of sex and sexual conduct, but the word has not to be used. And of course, acts against nature, the choice correspond to the moral that the Vichy regime wanted to promote, but it was maintained after the liberation and until 1980. it was considered as an old-fashioned word and not adapted, but it was maintained. It's another source of reflection for legal history. It's the question in a corpus concerning one country of the inertia of the vocabulary. Once a word is included in the code and used by criminal lawyers, it's difficult to change, even if the word has not the same meaning in the modern vocabulary, even if there are some more modern and adapted terms. I think that there is a great resistance of obsolete words in some cases.
Okay, thank you for your question. I think it's an interplay, a mutual interaction, a sort of a, let's say, reciprocal working together, because criminal law shapes behavior and social behavior shapes criminal law. And therefore, I'm not against criminal law having moral issues or trying to interact with morality, but there has to be a difference between the language of criminal law and the language of morals, because if we confuse them, we have to come from the other side. In the end, a state punishes an inhabitant, a civilian. So he's not punishing because of morality, he's punishing because of the law. And therefore, there has to be a strict difference between the language of criminal law and the language of morality. But the problem is, you cannot avoid that the society uses words of criminal law language and makes its own stuff with it. So we have no, let's take the word violence I used. It is a specific term in criminal law. It's not forbidden to use it in different ways, but as scientists for law, we have to say that's your way you use it. It might be emotional, moral, political, but we may not use it, take it back, because it can destruct or destroy our system. And this is when you say, what's the shaping? It's a mutual thing, but law has to be very strict, very narrow, and law has to be cautious. It has to be very, very cautious if a new word or a new meaning of a word is circulating, because that it's not necessary, but it could destroy the legal system. And that's the way I want to say, the Latin word is ultima ratio. It's only the last method you use, and if it's the last method you use, you should not take it at first glance, and say moral and law and religion and politics is the same and use the same vocabulary. Yeah.
Is there time for another question?
Of course, there's lots of time. Please go ahead.
Okay, all right. I am trying to reconcile Oliver's work and Anya's. And I guess the way I phrase the question is this. Anya, does functional linguistics offer help, potential solution to Oliver's Wittgensteinian dilemma? Or does functional linguistics tell him it's hopeless?
I think functional, it's great because you're I was going to ask a question of Oliver and you're allowing me to ask it by answering your question. I think from a functional perspective, I suspect Oliver may be asking of criminal law terminology a kind of stasis and solidity that at least from a linguistic standpoint, we don't necessarily assume any kind of terminology will have. So I'm not saying it's not possible, but I'm saying I don't think that this is what we think of as the norm for language terminology. I actually was wondering, so I'm going to now take John's question and throw it to Oliver as well. you're talking in terms of linguistic change, and I see what you're doing from a kind of policy perspective, from an ethical perspective, trying to cabin and constrain the reach of criminal terminology. But to me, it seems like what you're really describing is a political process in which different parties vie to impose or imbue words with different kinds of meanings. And you're now a participant in that political process, right? You have a stance about how we should view these words, which that's not a criticism. I think that's great. That's appropriate for a legal scholar. But to me, it's more like you're coming at it from a kind of normative standpoint, but what I see you doing is really describing a situation in which different participants in society together are carving out the line between allowable use of criminal terminology and what goes beyond. So I guess that's not really a question, that's just kind of what I'm seeing happening, and I'd be interested in your perspective on that.
I would say that describes what I did perfectly. Yeah, that's it. As a lawyer or as a scientist for law, I would say I have a neutral perspective, but no one has a neutral perspective. So I have to redefine it. I tried to fight against the movement that unreflectedly uses the same words. And it's a process we cannot stop it because language changes, and it's good that language changes. A lot of words that were used before, we do not use them any longer. They changed their meaning and so on. It's not to say criminal law is not allowed to have new words, but criminal law should be, let's make an exaggeration. It should be the last instance to change its words because it's no need, even if there's a new moral problem in the world. For example, we can make a concrete example. In the COVID disease pandemic we had, there were a lot of moral questions, a lot of philosophical questions. And we had the discussion in law, do we need new law for this? Do we need new words to it? And the answer was no. We had all the words. We had all the solutions, all the words, all the criminal law, all the distribution law. And only in the last few moments, we said, oh, that's a really new, absolutely not existing phenomenon we need a word for. And that's it. It's what I did is more, in January, I talk more to my colleagues than to others because others can change the words. But to hold the autonomy of my own law science, we have to bear in mind that changing the words destructs everything law is. Law is just words. There's nothing more than a word. And if the word has no meaning, then there's no law, up to my opinion. But you are right. It's describing, it's claiming, it's a specific way of methodology. It's not empirical in the end. It's not an empirical way. It's describing a movement we all know and try to give words for the thing that is happening. Thank you.
Perfect. Any other questions or comments right now? Otherwise, I think, yeah, Tatiana or Janny?
Yeah, I just had a quick question for Anya, if we still have time. I was just wondering if you think I enjoyed your presentation, and I was wondering if you think that it would be possible to define fair notice with respect to any requirements, sort of standard setting. Is there a way of working out requirements or standards for how much fair notice is sufficient for different, situations?
Yeah, I think that's a great question. And it's actually not a question that, as far as I've seen, proponents of ordinary meaning in statutory interpretation who rest on the normative idea of fair notice, I've never seen anybody discuss how much fair notice and to whom and what would constitute it. I definitely think it's possible to set those standards, but I suspect they would be pretty vague in general. You know, the way people talk about it is, well, people should be aware of the requirements on their conduct or the restrictions on their conduct, which sounds specific, but I think once you get into it, can be, you know, quite deceptively so. And I guess that's another reason why I think we should really treat this as a whole of government obligation, because when you have different kinds of notice coming from different kinds of sources, you're more likely to inform people at least of something, as opposed to the current situation where we ask statutes to inform people of everything, and in fact, they inform them of almost nothing because of the way they're written.
Okay, thank you. Then I would propose to move on. There will be time to pick up things which we will not be able to cover now in the open discussion at the end. But now let's move on to the second panel. Our first presenter there is Professor Janny Leung, Professor of Linguistics at the University of Hong Kong. Please go ahead.
All right. Just 1 second, pulling up my slide. Okay. This is a little bit more chaotic than I have imagined. Can you see more than the slide?
We can see your whole desktop at the
Okay.
moment.
Does this help?
Yeah, this helps a lot.
Okay,
Perfect.
let's just do this then. Okay, so I've been working on a project that involves looking at court interpreters from all around the world, and I stumbled upon these judgments in Ontario that intrigued me. So this is the story about what has been going on in Ontario courts in relation to court interpreters. The impression that you're going to get if you read these judgments in Ontario is that judges have been fuming and screaming with frustration, and there have been one crisis after another that has happened in Ontario courts. I was looking into the academic literature about this saga that has been going on for at least 20 years, but no one seems to have written about it. So I've taken the liberty to write a paper on Ontario courts. Okay, so in Canada, the right to the assistance of a court interpreter is guaranteed in Section 14 of the Charter. So this is constitutionally guaranteed right. Even in the criminal code, if a defendant were to be present in his trial, which is a basic, fundamental fair trial requirement, linguistic understanding is supposed to be part of this. So if you don't have an court interpreter, then you're not presumed to be present in your own trial. It's not just having a court interpreter, there's also the quality of the interpretation that's provided in the assistance. And the standard is defined in a case called Tran issued by the Canadian Supreme Court. The requirements is that the interpretation needs to be continuous, precise, impartial, competent, and contemporaneous. All right, and the unit, the administrative unit in Ontario that's responsible for court interpreter services is called Court Services Division, CSD. All right, so the case that started all the discussion in these judgments is called Sidhu. What happened there was that Punjabi interpreter worked on this case, and then there were questions raised about the quality of his interpretation. So an external independent assessment was then conducted, looking into the recorded interpretation of this interpreter. On a 36-page transcript, this Punjabi interpreter was recorded to have said, like 27 times, like showing lack of understanding as to what's going on really in the courtroom. The review found that his interpretation was incomplete, inaccurate, and at times he was also leading the witness. It was thanks to a very activist judge in this case who was alarmed by what he saw in this report, and he conducted a whole research kind of project investigation as to what really has been going on in the court interpreter systems. Like, how did this happen that you have an interpreter who seemed so incompetent being able to work in the courtroom? His investigation, which is published as part of the judgment, reviewed that the Brampton court, which he was adjudicating in, not only used accredited interpreters who seemed incompetent, but it also routinely used unaccredited interpreters in the courtroom. And he has data as detailed as this. In a period of 4.5 years, there were more than 3,000 days in which you will find unaccredited interpreters working in courtroom in Brampton, in Ontario. The judge characterized CSD's attitude towards Section 14 as one of profound indifference. He also called the whole situation a sort of institutional recklessness. So again, but how did this happen that unaccredited interpreters were used and accredited interpreters were so incompetent? And he dived into these issues in the judgment. First, if you look at the accreditation test that has been used for a long time, until around 2009, the test is called the Standard Aptitude Test, which actually does not assess foreign language proficiency. You might be surprised. Candidates were tested on their English ability, the ability to do recall and shadowing in English, but no speaker of the target language audited the results. So you would be asked, if, let's say, if I claim to be an interpreter of English and Cantonese, if I took this test, I would be asked to translate. But no one is looking at my Cantonese translation. They're only looking at my English ability. So instead, what they have is an administrator who's likely bilingual in English and French, who would listen for the fluency of my Cantonese, even though they're not a Cantonese speaker. That's the extent of the accreditation test that has been in place for a long time in Ontario. It's not that they were not aware that it would be nice to have a foreign assessor, looking at the foreign language ability. But the test administrator who was testifying in the case in Sidu told the judge that they didn't have the budget to send out the tapes. So they kind of recorded the translation, but didn't actually have foreign assessment of the language proficiency. And in parallel to this flawed accreditation test regime, there was also flawed compliance. So there were ministry policies concerning like what kind of interpreters you can use in a courtroom. It's not that unaccredited interpreters cannot be used in a courtroom, but if they are used, then that needs to be kind of additional scrutiny. The judges need to know that someone is unaccredited. The judges then can conduct their own additional inquiries about the competence. The parties need to be informed. None of this was done in practice. So unaccredited interpreters were used sometimes even when accredited interpreters may be available, because there's a system in which each interpreter is assigned to the home base, like home courthouse. If you assign an accredited interpreter from some distance away, the courthouse that does the assignment have to pay for the mileage and food and possibly hotel costs for these further away interpreters. So some courthouses, instead of paying for an accredited interpreter, they decided to just go with someone who is not tested. Now, this very elaborate judgment in Sidu has led to changes in Ontario. So that's why I've called this pre-2009 system. Around 2009 and the year after, a new accreditation system was implemented because the old one has been thoroughly discredited by a judge. So I'll talk about what happened since 2009. So the Ontario Ministry had then engaged Vancouver Community College to devise and administer a new accreditation test. This new accreditation test has a really high failure rate, which by itself, it doesn't seem to be an issue. Like maybe they are, really filtering out people who are not competent. In the new policy, fully accredited interpreters can work in all types of proceedings. Conditionally accredited interpreters can only handle less complex matters. So this is a system where if you achieve a score of 70 or above, you get full accreditation. If you score anywhere between 50 and 70, you are conditionally accredited. If you score below 50, you failed the test. The immediate impact of the implementation of this test is that there was a huge shortage in court interpreters in the courtroom. So because a lot of the existing court interpreters failed the test, or they were only able to obtain conditional accreditation. So for a period of 10 years or so, you have judges basically having to delay cases, throwing out cases because there wasn't any available interpreter for a particular language pair available for their cases. So judges were very frustrated. They were describing competition between courts as being cutthroat. You have judges trying to poach court interpreters from a neighboring courthouse to try to make sure their cases are covered. So you have that kind of logistical complication. So that's one thing. But you would think this is just a teething problem because, you implemented a new system, you have new standards. It might just take time to build up a new registry of qualified people. But then in 2011, in another case called Dutt, and in fact, this Dutt case was adjudicated by the same judge who led the investigation into do. So the same judge now take a good look at the new accreditation system, and he reviewed a whole set of new flaws in the new system. And that's kind of how the saga keeps unfolding. So in this new system, and you have to give it credit in that there's some improvement in the new system. For 24 high demand languages in Ontario, which is around 85% of the provincial demand, you do have bilingual testing now. So you have a test that includes sight translation, consecutive interpretation, simultaneous interpretation, which directly assesses language transference skills. So the foreign language ability is assessed. The problem is that you have two other pathways to accreditation that now exist for other languages. So the other 15%, so which we can call languages of lesser diffusion. So you have this other pathway called English only pathway, where this is similar to the old SAT test, where the foreign language ability is not tested. You're tested only on your English ability. If you pass this English only pathway, you get the same piece of paper that people pass to the bilingual pathway. So it's the same accreditation system. And then they also have this 2-for-1 deal thing, where if you pass your accreditation in one of the 24 languages, and you say that I actually speak this other language as well, then you can be automatically qualified for this other language. So they're kind of these two important loopholes that are now creating problems. And I'll just give you one illustrative case, and there's actually quite a number of cases that illustrate this, but this one is particularly dramatic. This is a very recent case that happened last year, where the court provided a Cantonese interpreter to a Thai Chinese defendant who does not speak Cantonese. Thai Chinese is a Southern Chinese dialect. It's neighboring to Cantonese. There's some relationship between them, but they're not mutually, you can't replace one with another thinking that they're the same language. What happened, the backstory to this is the interpreter failed to be accredited in Cantonese, which is her first language, through the bilingual test. So what did she do? She took an English-only test and tried to get accredited in Thai Chinese, and she was accredited. Her Thai Chinese was never assessed. So she's now fully accredited interpreter in Thai Chinese. Independent assessment of her interpretation suggests that her rendition was 100% in Cantonese. If you ask the interpreter what's going on, why did you do this? Like, why are you accredited in Thai Chinese? She expressed her belief that Thai Chinese and Cantonese were essentially the same language. And therefore, she doesn't feel that it was a problem for her to interpret for a Taiwanese speaker. This just tells you how flawed the current system is when you don't have an ability to tell whether someone speaks a foreign language at all, and then you can put this person in the courtroom to work as a court interpreter. Okay, coming to my analysis, where the current court interpreting system falls short. There are lots of challenges in operating a court interpreting system, but the kinds of problems that the Ontario system is facing actually are solvable. They're rather solvable if you compare with other systems and best practices in other parts of the world. First of all, the current system lacks tiered credentials. All this means is, and I'm using Australia as a comparison, instead of giving, so let me just backtrack for 1 second. There are, according to some estimates, more than 7,000 languages in the world. So no court interpreting system in any jurisdiction can have the ability to test the bilingual proficiency of every language that it encounters. So it's not so much limiting a certain number of languages for the bilingual testing. That's the problem. The problem is with the credentials. So you could develop a system where like the 24 languages that are highly used in Ontario, people can get an accreditation that says, this is a fully tested interpreter. And then you can have a different kind of credential. In Australia, they call it recognized practitioners instead of like a fully accredited interpreter. So you can have a different system where you can assess by dossier, oh, this person has worked as an interpreter in these other settings, in Taiwanese, for example, and it's a recognized practitioner based on all these references. So the judges at least have some sense that, okay, this person does not enjoy the same credential as this other person who has been tested bilingually. So a tiered credential system could help ease that confusion. Lack of recertification is another issue in the system. In Australia, I think court interpreters are tested every 5 years. The Sidhu case that I was talking about at the beginning of the presentation today, that interpreter has been working in the system for decades. There's no retesting in Ontario. So chances are that he was very good at one point, and maybe he's losing his hearing. And so if you don't have a recertifying system, this is the kind of problem that can happen. There's no support, ongoing training in Ontario. And one structural issue that I want to highlight is stagnant pay. So when they changed the accreditation system in Ontario in 2009, interpreters were paid around 25, 30 Canadian dollars an hour. And this is someone who does not enjoy any other benefits. The hourly pay is all they get. So if you increase the bar as to how much we're expecting from them, but without also an accompanying adjustments as to how you're compensating them, you end up in a situation where you have basically a huge shortage of court interpreters because people don't feel that it's worth their time. Like better qualified people may not feel that it's worth their time. Administrative accountability is important because it's not just okay, you have errors in the courtrooms and therefore you point your fingers at the court interpreters. A lot of these problems also come from how the system is administered, who you're allowing in the courtroom. And you might have a perfectly competent interpreter whose reputation feels tainted by others who should not be allowed in the courtroom. So how you administer the system is terribly important. There's limited interpreter training opportunities generally in Ontario, which again, it's a structural issue. In Ontario, because of these structural problems with the court interpreting systems, what happens, one huge consequence, important consequence, is judges then spend a lot of time, because now they have a suspicion about the quality of court interpreters that can show up in the courtroom. They spend a lot of time conducting voir dires, asking lots of questions to qualified, like accredited and unaccredited interpreters to try to investigate and find out whether these interpreters are really competent to serve. Some judges become very frustrated with the process. There's commentaries like, courtroom is not the linguistic laboratory, or they might feel that, imagine for yourself, how are you supposed to assess the language proficiency of a language you don't speak. And that's essentially what the judges are trying to do in these pretrial processes, where they're trying to assess based on largely circumstantial evidence. So the worst part of this is that a lot of judicial time is spent in a system that's notoriously already has a lot of huge backlogs, and this is another bottleneck that's unnecessary, but is there. The overall picture that I want to describe is that if you think about court interpreters as a profession, and the natural progression of a profession is that you grow from, think of your electrician. Instead of having to assess whether you can trust this particular guy as an electrician, if they have a license, you feel that you can trust them. So that's the essence of professionalization, that you can go from personal kind of inquiry to trusting the system. Trusting someone with a certificate is reliable. What you see in Ontario is a regression from that. So you're going from, okay, we can't trust the certificate. We have to go back to individual inquiry as to whether each person, each interpreter is reliable. That seems to be the overall picture that I'm seeing through these judgments. And finally, if I have the last couple of minutes, I will...
Yeah, could you please
this is
speed up a little bit? Thank you.
Yes, this is my last. So what I would advocate for is a sort of national accreditation system for not just Ontario, but for Canada. And this is has a few obvious advantages. So language is the kind of thing that benefits from economy of scale. So in Ontario, in a province, if you have difficulty finding interpreters for a particular language pair, chances that if you enlarge the pool, you're going to be able, you stand a better chance of finding a qualified interpreter. It facilitates labor mobility at a time where in Canada, the Prime Minister is talking about how you're going to take down trade barriers, mobility barriers across provinces. This is one example where the government can take the lead in taking down barriers. Increased prestige. If you have a national accreditation system, court interpreters might feel that this is something worthy of getting. And if you look at Australia as modeled, which they have a national system, what I'm just going to highlight one thing that maybe policymakers might be interested about that system, is that it's not a cost center. It doesn't just cost taxpayer money. It's actually, even though it's a not-for-profit company, it actually generates enough surplus to fund professional development and industry research. So if it is done correctly, it can actually lower our tax burden instead of increasing it. So I'll pause here. Thank you.
Perfect. Thank you very much. And if you could unshare your screen, that would be good. Now our next presenter is Professor Arpeeta Mizan, Assistant Professor at the Department of Law, the University of Dhaka in Bangladesh. Please go ahead.
Can you all see my screen?
Not yet. It says you started the screen sharing, but I can't see anything yet. Now we see PowerPoint, yeah.
Hello, good afternoon, and it's a privilege to be speaking here. I'm Arpeeta, and I think my paper is the only one that kind of deals with the global South societies dealing with post-colonial legal realities. I'm writing this paper with a colleague, Said Hussain Sarwar, who is working as a senior lecturer at the East West University, Bangladesh. In this paper, the title is The Language of Law, Gendered Ideologies in Bangladeshi Rape Judgments. So what we are trying to capture in this paper is how Bangladeshi rape judgments reproduce and occasionally unsettle gendered power through judicial language. So a socio-legal approach of language shows that law doesn't operate as an autonomous, self-contained system, but it's a social phenomenon, which is deeply embedded in cultural, economic, and power dynamics. In this paper, we are trying to see how the legal language as used by the judges reflects and shapes social reality, and how it has an impact in terms of approaching law in context and differentiating from the law in the books. Language becomes crucial in terms of both popular understanding and for theoretical and institutional application. There are two prevailing views on how the meaning of law operates in a society. This is called instrumentalist and behaviorist. The instrumentalists uphold that humans are conditioned by the forces of law and that people do not have independent agency to determine the meanings of law due to the influence of different complex attitudes. However, the behaviorists take a more socio-legal approach. They look at how law actually operates in a society and say that a person can actually decide what meanings ought to be associated with the words of law. In this occasion, we are specifically looking only at the rape judgments, which have been decided in the Apex Court of Bangladesh, which is the Supreme Court. And the reason we have chosen rape judgments is because existing feminist legal literature shows that the legal treatment of rape epitomizes the core of the problem of law for feminism. Drawing for Professor Carol Smart's famous paper, we know that female representations in the judicial process shape and structure the legal language around violence against women, which means how a judiciary particularly addresses rape decisions has broader implications for other violences such as kidnapping, sexual molestation, sexual harassment. And so existing literature shows that judicial decisions can be informed by rape methodologies. And so a social legal approach to this legal language shows that there are deeply embedded patriarchal structures which not only define what the law means, but also how the law is interpreted when human actors are dealing with this law. In the paper, we will be focusing on three specific patterns. We are going to look at agency, which is how the judiciary thinks about women as having their own independent agency versus women being a passive receptor of male violence. The second pattern we will be looking at is stereotype reproduction, like how the judgments keep reproducing the ideas of rape, and how women are represented as survivors or victims in the judgment. But for today's panel, we are only going to look at the stereotype reproduction. Stereotype here refers to the prescriptions or unstated expectations of behavior rather than specific to representational practices. And the importance of understanding stereotype comes from the fact that stereotyping practices can maintain the social and symbolic order. It often operates to establish gendered hegemony by naturalizing the masculine worldview. Moreover, stereotypes of women's behaviors and actions become hegemonic reconstructions and hegemonic ideological representations. It notes how traditional sexist stereotypes become so resilient that they are never contested even within a judicial space, which promises equality before law. Susan Elric, who is a sociolinguist, has demonstrated that dominant ideologies of sexual violence against women are often sustained and actually reproduced through institutional practices of judgment. And these judgments often render the women invisible, and they are reduced from conscious agents to passive subjects. In fact, if we look at the judgments from Bangladesh judiciary, we see that there are two specific words which are repeatedly used to refer to the survivors of sexual violence. The women are termed either as victims or as prosecutrix. And this kind of wording often reduces the woman as a human person and puts them in a box which divides them from their humanity. Before I move on to share some excerpts from Supreme Court judgments, I would like to share the definition of rape under the Bangladeshi criminal law. This is important because if you can see, the definition of rape comes from the Penal Code 1860. This is the first legislation that the South Asian countries, so India, Bangladesh, Pakistan, Sri Lanka, all these countries, when we were British colonies, received. This is the first legislation which was codified under the codification project of the colonial government. So this also shows how colonialism kind of shapes the legal practices. Even though Britain itself used common law and depended on case laws to develop legal precedents, in the colonies, the British colonial government reduced the legal practices through legislative instruments. So in Bangladesh, rape is kind of limited to only females. And so legislatively speaking, men cannot be raped under Bangladeshi law. A man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman under circumstances falling under any of the 5 following descriptions: against her will, without her consent, with her consent when her consent has been obtained by putting her in fear of death or of hurt, with her consent when the man knows that he is not her husband and that her consent is given because she believes there is another man to whom she is or believes herself to be lawfully married. Fifthly, with or without her consent when she is under 14 years of age. Explanation: penetration is sufficient to constitute the sexual intercourse necessary to the offense of rape. Exception: sexual intercourse by a man with his own wife, the wife not being under 13 years of age, is not rape. So this categorically excludes men, trans women, and gender non-conforming individuals from bringing charges of rape. And it also categorically excludes marital rape. It doesn't recognize marital rape as an offense. So I will first read out one judgment, which will show, it gives us a good glimpse of how the judiciary has traditionally approached the issues of rape. So this is a case from 1998, and this is one of the landmark cases. It's considered a landmark case in rape judgments. She categorically stated that out of fear of the accused persons, she and victim A1 could not shout. Being apprehensive of her honor and dignity, she did not disclose the incident of commission of rape upon her, and also of taking nude photographs to the authority of the college hostel. A girl in a tradition-bound, non-permissive society in Bangladesh would be extremely reluctant even to admit that any incident which is likely to reflect upon her chastity. In the normal course of human conduct, an unmarried girl would not like to give publicity to the traumatic experience. Her natural inclination would be to avoid talking about it to anyone, lest the family name and honor is brought to controversy. Corroborative evidence is not an imperative component of judicial credence in every case of rape. This last line is the reason why Al-Amin versus the state is considered a landmark judgment. This is the case where corroborative evidence was dismissed, and it was upheld that the survivor's sole testimony can be good enough to prosecute a rape case and find the perpetrators guilty. But then the court goes on to saying, The inherent bashfulness and feminine tendency to conceal the outrage of masculine sexual aggression are factors which are relevant to improbabilize the hypothesis of false implication. No woman of honor will implicate another person for the commission of rape, since she sacrifices thereby what is dearest to her. In a case of rape, no self-respecting woman, especially a college girl, would come forward in a court just to make a humiliating statement against her honor and dignity. Rape is not merely a physical assault, it is destructive of the whole personality of the victim. A rapist not only violates the victim's personal integrity, but leaves indelible marks on the very soul of the helpless female girl. The court therefore shoulders a great responsibility while trying an accused on the charge of rape. Now, apparently, this is quite a liberal judgment if considered in the context of the judicial trend in Bangladesh. A lot of the rape judgments in Bangladesh talk about technicalities such as medical evidence. How soon were the forensic evidence taken? Was there any DNA test done? Was there any semen present? How was the FIR charge sheet filed? But if we go beyond the technicalities, cases like Alamin become a rarity where they focus on how the victim kind of gave her testimony and whether, she was kind of found to be a reliable witness or not. So in our thematic analysis, we have found a number of words which kept coming up repeatedly. So this is nature, chastity, habituated sexual intercourse, free mixing, modesty, resistance. These words were not simply mentioned, but the way these words were used show that these concepts become a crucial consideration in determining whether a victim or a witness's testimony could be found reliable, whether the perpetrator is found to be, of a person who could commit rape, or someone, who becomes, it's unbelievable that a person like the perpetrator could actually even attempt to rape another woman. So, for example, if you look at Rubel versus the state, this is a much more recent case. Here, the court said, prosecution witness 7, who as a member of the medical board examined the victim, opined that there was no sign of rape on the person of the victim and she was habituated to sexual intercourse. It is improbable that the victim will go door to door of neighbors and report the incident to them. It is also against the course of nature that in case like this, the victim will give birth to a sound child after 15 days of the occurrence. In this case, the survivor was a pregnant woman. She was 9 months pregnant when she was raped in her own residence by a neighboring man. She filed in her police information that she could not shout when she was being raped because she was restrained by some other people while the perpetrator assaulted her. And after the perpetrator left, she informed her sister-in-law, her brother-in-law, and the neighboring houses. And another important factor to consider here is that the survivor in Rubel versus the state was a woman coming from a rural area. She was mostly illiterate, unlike the previous survivor who was a college student. Now, the fact that medical jurisprudence categorically states that just because a woman is 9 months pregnant doesn't necessarily mean she will not give a natural birth or she will not have a normal delivery of a healthy baby was kind of overlooked in this case. And the entire judgment hinged on the fact that this woman, because she was already pregnant, means that she was habituated to sexual intercourse. So since there was no signs of rape on or abrasions on her vagina, the court found it very unlikely that she was actually raped. This was not taken into consideration that a woman who is carrying a baby might not resist the sex, fearing the safety of her a child. And that lack of resistance does not necessarily mean she has consented to the sexual intercourse which has been forced upon her. Moving on.
Peter, sorry,
yeah.
I don't think we have time for the case. To be quite
Okay.
transparent, one of our last contributors has to leave quarter past,
Yeah, I'll just
unfortunately.
go to the analysis then. Yeah, I'll
so
just
and you
give
can break up
analysis.
the last case in the discussion maybe,
Yeah,
but
sure.
so just move on. Thank you very much.
No problem. So if we look at these different, I just had two more cases, so it's not a loss. So what comes out of all these analyses shows that the narratives of facts or relevant facts in determining a rape case are often organized around the metaphors of chastity, honor, and shame. These narratives not only impact the interpretation of evidence law, but it also shifts the voice and agency of the survivors. It gives us also a second set of thematic analysis, which indicates that the stereotypes often affect the credibility of the assessments. So if there is a delay in filing the police report, if there are absence of resistance marks on the perpetrator's body, so like if there are no scratch marks, if there are no beating marks, if there are no torn clothes found, all this culture and anchoring are held against the women. The third thing that we found from our analysis is there are mutually conflicting demands made upon the women. In Bangladesh, women from a very early age are taught to be humble, be very submissive, and be polite. But when it comes to a woman seeking judicial remedy against sexual assault, that woman is expected to shout, that woman is expected to suddenly gain agency and resist the man. She is expected to behave like an agencyful, like, a woman who is very much used to exercising her authority, exercising what she wants, exercising her willful agency in every given situation. So it's totally obviated and totally left beyond consideration that a woman who is every day subordinated to following out commands from her male family members will suddenly gain this agency and make decisions under the extremely unlikely pressurized situation of being subjected to sexual assault. So to kind of summarize, this shows that even though in post-colonial countries, we find a lot of structural intervention to address violence against women through making specialized laws, making specific tribunals addressing only sexual assault cases, such interventions will definitely, and I mean, as practice, so these kind of interventions actually fall short of expectations, and they cannot provide meaningful changes because they do not address the cultural probes, the cultural tropes that subject the entire judicial trial process. So we need to look at how the laws and their interpretations and how the trial proceedings, the language used in examinations, cross-examinations, actually bear upon the overloaded meanings. So I will stop here. Thank you for your time.
Thanks. Our last two contributors presenting together are Robin Riner, Professor of Anthropology at Marshall University, West Virginia, and John Conley, William Rand Keenan Jr., Professor of Law at the University of North Carolina. The floor is yours, and sorry for running late.
Okay, thank you. Get moving right away. Our issue is threatening communications and trying to take a linguistic view of that. So next slide, Robin. Okay, in this country, allegedly threatening communications are in the news every day. The former FBI Director Comey is about to go on trial for threatening the president for his strange 8647 message in Seychelles. 86 restaurant lingo, eliminate 47. Trump is the 47th president. Somebody else is about to go on trial because he stopped at a car wash and another customer called the police when he saw this message scrawled on his car windows: headed to WSH to kill the Prez. There's a video posted by New York Mayor Mamdani, and it's in support of a new billionaire real estate tax. And he filmed it outside the penthouse of a hedge fund billionaire named Ken Griffin. The video named Griffin and gave his address, and Griffin cited a tax on corporate executives as a threat to his personal, made this a threat to his personal safety. And of course, as Tatiana reminded us, law enforcement agencies everywhere are constantly engaging in threat assessments. So next slide, Robin. Here are some examples of relevant state and federal laws in the US. The top one is threatening the president, a California example, and the FBI definition of a threat. I think the key to this is how broad they are. Knowingly and willfully otherwise makes any such threat. The California Penal Code focuses on both the intent behind the statement and then the reasonableness of the recipient's interpretation of it as a threat. And the FBI's definition, as you can see, is very broad. Okay, next slide, please. And here's our question. What can linguistic theory and methods add to the understanding and interpretation of allegedly threatening language? Robin.
Okay, so what we'll go over briefly today is some of the linguistic theories that are used to understand the nature and interpretation of threats, how language, the language of threats, but also language ideologies can inform threat assessment, and that can be both at the level of prosecution, but also prevention. And then lastly, the utility of conversation analysis, which is a very specific linguistic methodology for analyzing threats and their potential to be enacted. So speech act theory is probably one of the primary theoretical perspectives from which threats have been examined. So threats in a linguistic sense have often been described as speech acts, which are utterances that actually perform actions. So they do something in the world. The sort of primary concerns here for defining a threat, right? The question being what actually constitutes a threat are what are called the illocutionary and perlocutionary components of a speech act. So illocution is generally thought to equate to sort of the intent. So what does the speaker intend to do with these words? And then the perlocutionary effects are, you know, what do the words actually do, right? So if I intend to scare somebody by saying something, that's the illocutionary act. And then is the person actually afraid, right? That would be the perlocutionary act. And scholars really disagree as to whether threats are defined primarily by illocution or perlocution. Interestingly, within the law tends to concentrate on illocution. That actually shouldn't be surprising to legal scholars, because we know that intent is such a huge portion of law. But some scholars really put the focus on the perlocutionary force of threats. You know, is the person actually intimidated? Are they actually afraid, right? I'm going very briefly through all this, happy to revisit any of it in the discussion and questions, but I'm just going to kind of blow through it here in the sake of time. So again, you know, when we're trying to determine what actually a threat is, should we focus on the illocutionary force or the perlocutionary effects, right? The speaker's intent versus the effects on the addressee. Another important aspect of threat analysis and determining what constitutes a threat, lots of scholars have pointed out that the language used, right, the words of the threat are not the only important component. So context is also key. So there's a complex network of contextual relationships that determine if a speech act actually is a threat. So it's not just the intent of the speaker, it's not just the effects, but it's all this contextual information that's also important, right? A lot of what threat assessments are trying to determine, especially from a prevention perspective, is whether violence is actually going to occur, right? Is the threat, quote unquote, real? And so, whether a threat portends real harm is based on psychological, cultural, and social frames. So those are all going to affect how the threat is interpreted. So again, focusing on threat assessment specifically, and there are lots of professional criminal justice actors who do threat assessment, police officers, investigators. So, from a linguistic perspective, the question is, can a threat's linguistic features help predict whether it will be enacted? And what we're really interested in is this third point here, that threat assessors, they have a list. You can see it here. There's a list that has been established of all these linguistic features that can potentially or supposedly determine whether a threat or the likelihood that a threat will actually be carried out. But what scholars have found is that, number one, these linguistic features aren't very predictive, actually. So when you take a large database of threats and analyze them, which lots of linguists have done, these linguistic features are not predictive. So what's really going on is that threat assessors are using their own language ideologies of what a threat is to assess the threat. And so we're interested in investigating those language ideologies. What are they? Where do they come from? What's informing them, right? I'm going to skip some of this. So the language ideologies about threats are informed by cultural ideologies about violence, gender, race, class, religion. So all of this should be part of a threat assessment. And this goes back to that context point, right? That context is incredibly important when assessing and defining threats. So I'm going to go to our last point here. So conversation analysis is actually, it comes from sociology. It's very closely related to discourse analysis. But we think it might be useful in sort of furthering this assessment of what a threat is, and then also the likelihood that violence will actually be the outcome. Because conversation analysis doesn't start with a given definition of any speech act. So a CA analyst will not say a threat is X. Instead, CA looks to the speakers themselves to see how they produce and then also attend to different speech acts, such as threats. So what our article or our chapter will do is to use conversation analysis to see how threats are actually produced in interaction, how are speakers and addressees attending to them, what components of the threats are they attending to, and then also what interactional features portend violence, right, if a threat is actually carried out. There's one study we've looked at so far that does this sort of live analysis of the development of threat into violence. They studied YouTube videos of violent interactions. And so they've started to identify these interactional features that indicate, whether violence is actually going to occur after the initiation of a threat. So again, part of what our chapter will do is to try to identify these interactional features that might help us better assess threats, better define them, and also assess their risk potential. So I'll stop there and leave lots of time for questions and discussion, and happy to return to any of those points that we made.
Perfect. Thank you very much. Yes, we have now time, 10, 15 minutes roughly, I would say, for a panel discussion on this second panel. Thank you all for sharing your ideas and thoughts. And yeah, please go ahead with any questions, comments.
If I can maybe invite Robin, if you, I wonder whether, like, I really like your point about, threat assessors often apply their own language ideologies in the assessment. Whether you can give an example of that, like perhaps for any of the examples from one of your first slides about Conley and others, like, is there?
Sure, yeah. So, and this will get to that sort of contextual component as well. So there was a study that looked at threat assessment, and this was not about sort of individual threats, but it was more the sort of idea of like a threat of a particular group. So they looked at Muslim versus right-wing extremist groups, and whether how local law enforcement agencies identified them as threats or not. And so what the authors found is that, probably not surprisingly, right, sort of racialized and religious ideologies played into the law enforcement agents' assessment of those threats. The authors analyzed the amounts of threats versus, so that, like, how in a local jurisdiction, how many threats were coming from each of these groups, and did that correspond with how the threats were being assessed, whether it was high risk or low risk. And they found that largely there was not correlation. So again, what was correlating here was political ideology. And so that's just one example of how, in this case, again, racialized, religious, political ideologies influenced how the law enforcement agents were assessing threats, if that makes sense.
I think language ideologies, belief sets about the nature of language, and cultural ideologies, the cultural context in which the language ideologies are employed, reinforce each other.
Yeah,
Janny,
Anya.
I had a question for you, which is a little bit out of character for me. I'm not a big booster of artificial intelligence, but I was thinking while listening to your presentation, I wonder if this is one of the rare places where it might actually be useful, because the translation function has gotten so advanced, probably more advanced than a Cantonese speaker trying to, speak another Chinese language.
Thank you, Anya. I had kind of anticipated that question in a way, and I have a paragraph in my draft on that. So basically, the challenge is that if you think of AI's translation ability, it's very good with languages that are most frequently used. So if you're translating between English and French, probably, pretty good. Where courts struggle most of the time is with rarer languages, which is also where AI is not very good at. So that's the problem. It's one of the problems, along with other problems such as privacy, confidentiality, questions as to consistency in terms of standards, in terms of accountability, in terms of, there's a lot of questions that are being raised. This is not to say that courts are not looking into it. There are jurisdictions that are looking into to what extent AI can be used to assist such processes. But yeah, the challenges remain, especially in terms of matching between the smaller languages.
Yeah, I would say that the use of AI is the problems we've been talking about on steroids. AI embodies language ideologies, it reinforces them. Cultural stereotypes are part of the application of language ideologies. What's the database that the AI worked on? What's the human factor there? So I think what we're looking at greatly exacerbated, exponentially greater.
no one else has a question, I wonder whether I can go back to Tatiana actually from the first panel, because I think I have a question for that we haven't had a chance
Yeah, I think
to.
we can open up discussion.
Right. Thank you, Tatiana, for the very interesting paper. I was curious about to what extent cultural sensitivity becomes an issue in your project, because when it comes to domestic violence, relationship between spouses, like and trying to use like more kind of objectified kind of form and all, how do you deal with that issue of cultural sensitivity, or has it come up as a problem in your project?
It comes up as a problem at different stages and for different reasons. And I think that's one of the reasons it's really important to look at sort of where it potentially is more of a problem. At the very initial stages, the caller, a victim, usually a victim survivor, would need to make that decision, conscious decision, and call the police. And so that's when they need to identify that they have a problem. And that is one of the kind of cognitive challenges where if they're from a cultural background and plays a role. The second stage is then when they get to the call and they get to potentially the risk assessment stage, they will be assessed, or their risk will be assessed either online or in person, depending on the circumstances. If it is online, and online tends to be assessed by the duty desk officers, the DA domestic abuse desk officers tend to be more experienced, more senior, and it's an online environment. It's a little bit more neutral, and the desk officers are non-uniformed, so it creates a little bit more of a different setting as opposed to in person, where the police officer comes into your home, often home or somewhere else, and they are uniformed and they are wearing body-worn cameras, and they start with that risk assessment. So online tends to be easier for essentially to build rapport. And the cultural aspects that enter that stage also, they come from the police officers as well. And because the online environment is usually run by more experienced police officers, they've seen more. So they tend to be able to navigate the situation a bit better. And the satisfaction, the victim satisfaction, tends to be much higher with the online desk assessments. The third stage where the cultural aspects are really important is when victims are asked about their perceptions of the threat that they are facing. And the last one is when they are asked about what they want to happen to their situation. If they want this, for instance, there is enough evidence, if they want the perpetrator to be prosecuted or not. So it's a really, really interesting part to look at, and actually plays a huge role. And I think it's very much about raising awareness about first of all, the fact that victims can have the voice and should have the voice, and they can have the voice across the different stages. But equally, awareness as a separate issue, as a crucial issue as well, the awareness about the fact what domestic abuse is and the different types of domestic abuse. So really interesting. And I think once we start looking at the actual recordings, we will be able to uncover a lot more. Thank you so much.
If nobody else has a question, maybe I would go back to you, Arpeeta, and maybe ask you, maybe would you like to address one of those cases, and maybe how, this is one thought I had during the discussion, how your research, for example, relates to Oliver's research, which is more like from a legal professional viewpoint, versus your social legal perspective, and that would be very interesting to hear.
Thank you, Morten. I don't think it's necessary to go back to the judgments, but actually, when Oliver was speaking, I was thinking about some recent incidents that shaped a number of Gen Z protests back in South Asia. And I kind of picked on two words that you used, fascism and mob. This became kind of buzzwords for the South Asian Gen Z protests, specifically in Bangladesh. So what we have seen, my main area of research is legal consciousness, where we study how ordinary people, those who are not legal professionals, understand the meaning of law in their day-to-day activities. And I think when it comes to countries like Bangladesh, where we have a lot of legal pluralism, so we see state laws constantly vying for authority with other normative orders, specifically cultural practices and religions. These legal words, legal concepts and meanings become much more important than just being instrumental terms in determining trial outcomes. I think Oliver actually mentioned that when certain words become loaded with contexts. And it was a very apt example when you talked about like epistemic injustice and other kinds of injustice, like what does injustice or what does violence mean? And so I think these judgments show us that even though South Asian countries have taken up a number of reforms to address gender-based violence, not connecting the dots between legal reforms with other kind of sociocultural norms means that any kind of structural reform remains half empty. So we are just going half the way in terms of understanding the processes. And I think in terms of a social legal scholar, and if I want to connect my work with Oliver's, I would say this idea of meaning becomes very much relevant because, like Oliver said, law has its own disciplined set of boundaries, and legal professionals should vie to use those boundaries for clarity. But what we see in non-European, non-Western countries where often the hegemony of non-legal norms are much more powerful and much more authoritative than state laws. So it doesn't really matter what state law says if social or cultural meanings are having a far more obedience or far more impact on settling certain understandings. For example, one of the judgments that I didn't actually share was where the victim was a 20-year-old woman and the alleged perpetrator was a 15-year-old boy. And so that case became another landmark judgment in terms of child rights, in terms of, whether our justice system is acknowledging the best interest of the child principle. But again, the entire judgment was hinged upon the fact that a 20-year woman cannot be forced upon by a 15-year-old boy. A 20-year-old woman is supposed to have shouted. She was supposed to, resist a person who was 5 years younger than her. And so we constantly come back to the idea that when we look at law as an instrument devoid of and detached from sociocultural elements and sociocultural forces, law often fails to do its job because law always operates through the human factor. And so it is the human factor who is embedded and who is a lot of the time influenced by other socio-legal normative factors. We have to look change our focus from law as an instrument to how law becomes subservient to those forces. And I think that's where the socio-legal approach comes in. Because again, at least in South Asian legal academia, when we talk about these issues, we tend to detach law and we tend to approach law from a very positivistic normative perspective. And I hope that this kind of work will kind of, look at the feminist perspective, look at the judgments from a feminist legal perspective, that how should these laws be read and how should these laws be understood, both for the judge who is sitting in those tribunals, for the trial advocates, for the defense lawyer, as well as the state public prosecutor who are dealing with those laws, to understand the woman standing is not the same woman who is maybe a lawyer, because a woman who only manages a household in a very detached part of rural Bangladesh has a very different worldview than an urban woman like me. So I am not the standard of criminal justice system. And unless law manages, unless the justice system manages to incorporate those worldviews and acknowledges how those worldviews interpret the laws, we will be a long way distant from our goal of achieving gender justice through laws. I'll stop here. I don't know if that answers your question.
It was a great point, I think, and a lot of things to think about. And yeah, any quick replies or comments on that? Because I would like to wrap up 1:30 maybe, but I would like to leave you the room. If not, just thank you for all your contribution to this panel. It was really great listening to you discussing this very interesting topic. Before we close, I just have a few final announcements. Please keep an eye out for the special issue. So I'm looking forward to the written contributions. The special issue will be published, I think, later this year in the Modern Criminal Law Review. And the easiest way to stay informed about upcoming MCLR Plus events, publications, and projects is to just regularly visit our website. Please consider signing up for the MCLR Plus mailing list, and you can also subscribe to this YouTube channel. We also have another interesting event coming up on June 24th. We will host a special issue workshop on ancient criminal law, guest edited by Clifford Endo. So please feel free to join there as well. And yeah, all that is left to say now is thank you all for having the time and sharing this panel with us and having this engaging discussion today. I would also like to thank Professor Markus Dubber, who's not only the driving force behind this MCLR Plus project, but also worked behind the scenes today to make this event possible.